position is that, as has been said, there really is no reason to grant a continuance of the board's recommendation in this matter. Of course, in addition, the board's recommendation will then have to go to the commission. The commission will then have to approve it or not in public hearing, and that will then be sent out to an administrative law judge for determination. And if the Board of Rights is going to go forward in April, just simply as a matter of calendaring, this matter wouldn't go to the board until, Anne Marie, what are we talking about, March for the commission meeting? March. The commission meeting would be in March. If the commission approves it, it would refer it back to the division. We would engage the Attorney General's office. They would file an accusation. It would start the process of that whole discovery and that whole administrative hearing. So the Board of Rights would likely be concluded in any event well before the administrative hearing occurred. So if you have any questions, I'm happy to answer them. Okay.
Would you like to respond to any of the responses you got, counsel?
Yes, thank you.
Sure.
I would just like to read into the record what the Post website says specifically regarding the issue of a continuance or a deferment. When a peace officer appeals discipline relating to serious misconduct, does that delay the decertification process with Post? The answer is generally, Post will toll any determination or recommendation for decertification pending the outcome of disciplinary appeals or civil or criminal actions. So that is what I was relying on in my request for continuance. I would also like to respond to Ms. Del Magnaio's response that my request for a continuation was not received until December 5th, which after this was posted for public comment. As I'm sure you all know, this is our first time doing this. I was not given any sort of notification about when any request needed to be received, and was told to come ask the board directly for that request, which I did here today. If there is a process that needs to be in place for representatives of law enforcement officers to be able to make those kinds of requests, I would ask that that be given to us in advance so that we can make this process more smooth and more streamlined. Also, I believe the relationship between this board's duty in making a recommendation for either suspension or decertification is related to the hearing at the Board of Rights. If you are in fact searching for the facts and the truth and the why on why Detective Fillmore behaved as if he did. I think that that's a very serious matter for this board to consider in its recommendation. I would also note as my last point that it appears so far, at least on the information that I can glean from the website, that all other revocations for law enforcement officers in this state have been for felony convictions, and Detective Fillmore does not have that same status. And so I would request that if the board does choose to move forward, that it move forward on a recommendation for suspension instead of decertification. Thank you.
Okay, thank you. First, there is no discrepancy between what you read and what Chief Counsel Darden read. He responded to the statement that says generally, and said that this was specific. As to the second point.
Thank you, Ms. Wilcox. Yes, we sent out the notice of intent to revoke in late December. Actually, that's not true. We sent it out in mid-October with a 30-day response period for an appeal. So there was a 30-day window within which the officer's counsel could appeal the actual notice of intent to revoke. We did receive an appeal regarding this matter on November 21st. We did not receive a request for continuance until December 5th. At that point, we had already moved forward with posting the information and obviously sending it to the board for review and consideration. In terms of the final resolutions of anything that has been taken, final actions that have been taken by Post, the reason that the only actions at this point are as related to felony convictions is because this is the first hearing of the board where they can consider acts of misconduct. The felony conviction statute, Government Code 1029, is an absolute. So if an officer suffers a felony conviction, they shall be revoked. There is no discretion on the part of the board or the commission or anyone else for that matter. So that is the reason why the current resolution, if you will, for all of the matters that are posted on the Post website are revocations as a result of a felony conviction, because we are today considering our first hearing for serious misconduct unrelated to a 1029 violation. Thank you.
Thank you. Are there any questions from the board for council? Yes.
For clarity purposes, Clavo, I'm sorry. You stated that your client did not dispute that he disputes that he did not have permission to have his car home stored. But does he dispute the fact that he did not have permission to drive said car while off duty?
That's a little bit difficult to answer because of the way LAPD handles their off-duty vehicles for people who are allowed to have cars off-duty. He was responding to meet a supervisor. He definitely did not have permission to drive it while under the influence. He's not disputing that. But he did have permission to have the vehicle in the manner in which he did.
Thank you.
When you're saying the manner in which you did, but not to drive the vehicle under the influence of alcohol, you weren't
Of course
suggesting
not.
that. Okay.
Of course not.
Yes, board member Laura.
I have a
Oh, you
question.
didn't. Okay. Yes.
Hi, Glazer. I wanted to get some clarification on what his current status is with respect to his ability to serve as a law enforcement officer currently. I know that he's described in the report as being relieved of duty, but he is still apparently an employee of LAPD.
It's a little confusing. I actually have this dispute with the department all the time. He's relieved of duty is a terminology that they use, meaning that he doesn't have a badge or a gun. He has no police powers, even in an off-duty capacity, under the penal code. That for LAPD, once they have determined that they want someone to go to a Board of Rights to be considered for termination, they are still on the payroll of the city for 30 days. After that, they are no longer on the payroll of the city, but the department still believes that they have control over that particular employee while they are pending their appeal. I don't know if that clears it up.
That partial
Okay.
clarification, thanks. And then I think my question is for other people as well, which is, what is his status with respect to Post at this point? Is he under an immediate temporary suspension? Or, is he, yeah, I think that's my question.
Okay.
Is he?
I'll ask Anne Marie to respond to that.
Thank you, Board Member Glazer. No, he is not. And the reason Mr. Fillmore, Officer Fillmore, is not under an immediate temporary suspension is there is no authority in this case for the executive director to take that action because he has not been terminated. He did not resign during a pending investigation, and he was not arrested or indicted for a felony matter. We don't have the authority to issue an immediate temporary suspension. Thereby, Mr. Fillmore is, at this point, his certification status is free and clear. He could seek employment from another agency. He's not restricted in terms of his ability to retain a law enforcement position elsewhere.
Anything else, Mr. Glassy? No. Thank you. Ms. Pena.
I have a couple of questions, actually. I'm trying to understand the Board of Rights versus the revocation proceeding that we're considering here today. Let's say, for example, we recommend revocation. It goes to Post upholds that. Does the Board of Rights hearing still go on? And if so, how does that then impact a Post decision on revocation? I'm asking actually any of the attorneys.
I'll just speak to the Board of Rights part, if I may. Sorry, you can go ahead.
Go ahead.
Okay. Again, this is all new to all of us in this area. My belief would be that if this board and the Post Commission at its final decision revokes his peace officer certification, then I think under his MOU, he would have a right to go to a Board of Rights and still appeal that, but they would not be able to reinstate him to his position because he wouldn't have a certification.
Anybody else on that?
So I just want to reiterate what Mr. Darden had explained about how the two tracks are completely
Speak
separate.
up.
Sorry, is it picking me up? The two tracks, the disciplinary track between the officer and the agency, that is completely separate from our revocation process and the statutory scheme that is set forth by SB 2. So the outcome of the disciplinary proceeding or the appeal with the Board of Rights, it really has no bearing on our decision to move forward with revocation.
It's somewhat intentional, right? This board is making independent recommendations, independent of the agency's determination of their employment issue, right? And so they're discrete and unconnected. Does that make sense?
Yes.
And an agency decision does not preclude Post from moving forward with the recommendation for decertification.
Other questions?
Second question is, and any of the attorneys, feel free to speak to this. Is there any significance to be obtained from the fact that the first offense was more than 4 years before the second offense? Does that matter at all?
I can respond to it from the board's position. I believe the reason, and the division can speak to this, that this was brought to everyone's attention was because of the contract, for lack of a better term, that was articulated. So after his first DUI, he entered into a contract, and you read the terms and conditions of that, not drinking alcohol, not going to a place where alcohol is served, and more of that. And then certain number of months later, he violated. I think the point was to show the information about the fact that he had these very strict terms and merely months went by before he violated them, but to also show that in fact the 4-year period had ended. Anybody else want to say anything about that?
I would just only note that the contract had ended. It wasn't a violation of the contract.
Correct. He was not in violation of the contract and it ended. I think it was 9 months previous.
Is there any significance to that?
Only in whatever significance you place on that.
Oh.
There's no legal significance.
Okay, thanks.
Any other questions, Ms. Pena?
I do.
Yes, Mr. Johnson.
Yes.
Ms. Pena, is that all your questions? Okay, Mr. Johnson, please.
Okay, I'm kind of still stuck on this idea when I use the word bribery. Because in the report, and I guess I'm just trying to understand if he really accepted his responsibility for what he did, but it states, on at least 2 occasions during the investigation, Fillmore attempted to use his position with the department to secure release and avoid the ramification of his actions. He told Morgan that the two were on the same team, that the investigation did not have to go this far. And if it were up to me, I would let it go. And of course, it goes on to talk about him attempting to hide this matter. And so it's very concerning to me that we're being asked, I guess, by his counsel, you represent him, correct?
Yes.
To overlook this, to give him time. And so I'm troubled with that. I just want to put that on the record.
And I think the council made reference to it, and I believe, and please correct me if I'm wrong, when you said he is required to let them know that he is a member of law enforcement when you work for the LAPD. And that was in reference to the articulation of that position. It was not in reference to everything else you just read.
That was just that his department policy requires him to identify himself as a law enforcement officer, and for the agency that he works with, anytime he's contacted by any other law enforcement agency aside from a traffic ticket. And that, as the law enforcement consultant here for Post indicated, that can often be misunderstood, and we do not have all the details regarding that particular interaction.
It's just troubling in the report that he, at least the investigator said he attempted to use his position, not just showing the badge, but attempted to use the position to just totally make this go away.
Well, you have the words there for the part of the same team and the other things you read. Thank you. Other questions for council, for public comment, council? Okay, thank you very much for coming in.
Thank you all for your time.
Okay, now, any other public comment? Seeing none, I now go back to the board and ask if anybody would like to go into closed session to discuss this further, or does everyone want to stay out here and have any further discussion that we might have? So first the question, anybody want to go into closed session?
I would like to go into closed. session.
Okay.
Yeah.
Okay, let's go into closed session, and let me ask you, do you need a break? Okay, so we are going to have a break, and then we'll resume in closed session at 20 to 12, 10 minutes from now. meeting is. But just to get you squared away on the timing. And we are not quite on the record. If we do end by 12:45 and you still want to stay for lunch, lunch is ready. You still have to pay Chandler $14. Okay. You tell me when you're ready. No rush. Closed. Thank you. We're back from closed session. Are there any additional comments or questions from any board members? Seeing none, is there a motion?
I'd like to make a motion to decertify.
Okay. Is there a second?
Second,
Okay. At this point, we'll take a roll call vote. The motion is to decertify this, to recommend to the commission that this officer be decertified. Mr. Wallace, Mr.
Board Member Buchan. Board Member Clavo.
Aye.
Board Member Crawford.
Aye.
Board Member Doyle.
No.
Board Member Dudley.
Aye.
Board Member Glazer.
Aye.
Board Member Johnson.
Aye.
Board Member Lara.
Nay.
And Board Member Pena.
aye.
What does that tell us?
We have 5 yeses. And we have 3 nays.
So again, this is based upon a majority. So that motion has passed. And the recommendation to the commission that this officer be decertified. Now, as to upcoming meetings, we have a meeting on March 20th through 21st, May 15th through 16th, July 24th through July 25th. All of those meetings are here at Post in West Sacramento. There has been some discussion about a meeting in January. For those of you who are here for the first training session, we set aside a January date as well. There's been some discussion that we might want to debrief the process at that meeting. It would probably not be a hearing, but we don't know that definitely yet. But if it weren't a hearing, it may be a time for us to meet to discuss how this process went and any concerns or questions you might have about the process before we come back in March. So I'm going to ask Anne Marie to comment on whether she thinks there'll be cases and the possibility of meeting in January for that debriefing / training session. Anne Marie?
Thank you, Madam Chair. There will not be a hearing in January. It takes roughly 8 to 9 weeks from the point that we receive a case and a notice of intent to revoke goes out for us to be able to meet all of the timeframes, procedural timeframes to schedule a hearing. So our next hearing will be March 20th and 21st. In terms of additional training, I would offer up maybe an opportunity to meet in February, and we can send out some potential dates. February.
I think several board members have that January date, not the February date.
Correct. But in terms of, we are offering training to the commission with regard to the procedural overview of case review in February. And just for the sake of staff preparing for an additional day of training, it would be helpful if we could combine that effort and offer training to the board and training to the commission around some of these procedural steps, answer more of your questions about the process, about the case review, about the hearing stages, et cetera. So what we're in the process of doing right now is we've identified some dates in February. I don't know if we have all of those dates in front of us, but we were going to send out a doodle poll, that's we've done in the past, and determine how many folks are available on what dates, and then try to set aside a day for training where we can, again, revisit some of the administrative overview.
Okay, anyone want to comment on not meeting in January, potentially meeting in February?
Well, if there are going to be no cases, then there's no need for us to meet in January, correct?
There is no reason to have a hearing.
Right.
But for those of us who were here for the first training session, we put those dates aside. I understand it'd be very complicated for the staff, but I just want to give you all the options.
You know what the dates are in February? And I think it's smart to combine, so
Yes.
staff doesn't have to do it twice.
And Ms. Wallace is going to help me out here.
It's going to come in doodle, and we're either going to be able to do it or not.
Just as a matter of procedure as well, in terms of the traveling to the hearings or to the board meetings, Chandler wanted an opportunity to kind of review reimbursement for you folks, since when we have you in what's called Cal-8ers, that's going to change a little bit. So if we have time for that, Chandler can kind of go over just what to expect for reimbursement.
Okay. Let me see if there's more discussion about the timing of the meetings. Anybody else just going to wait and see about those February dates, see if they work for you, but we already have the March. Okay, I'm seeing
did.
everybody nod.
I did have a question concerning our next hearing date, I believe was in March 2020 or 21st. Do we know how many hearings we will hear per meeting? We don't. Okay.
But the other question is, so we don't know whether we'll need 1 day or 2. We put aside 2 in case we have a lot of hearings. But generally, the way we know how many hearings we're going to have is, you heard Anne Marie talk about that 30-day rule. So they get letters and they have 30 days to respond. We don't yet know how many letters will be sent out, and we don't yet know how many will want to come before this board. Okay, is that correct? Okay. Okay, so I think we know where we are, and let's turn to Chandler for our travel.
Madam Chair, thank you. I just want to touch quickly on how the reimbursement will work for the purposes of this meeting. You will receive digitally a letter of agreement from me, and that's going to contain instructions on how you will go through the reimbursement process. Now, as Anne Marie mentioned, we are going to eventually have you guys logged into Cal-8ers to where there's a direct bill to the division rather than yourselves. Until that occurs, we have to do it the way that we've done it for this meeting, as far as your travel and hotel accommodations. So I will walk all of you through that process, and you should expect that letter of agreement emailed to you likely by close of business today, but we can touch on all of that individually, get you through it. Thank you.
So I was talking to Anne Marie, so I wasn't able to hear that last part. For now, we pay for our own transportation and we get reimbursed. At some point, there may be some ability for Post to pay that ahead of time and working through the travel agency, but we're not there yet.
We're not there yet.
Okay.
Correct.
Thank you. Question?
So on the training, is it during Monday through Friday, not weekends?
All trainings are Monday through Friday.
Okay.
But we don't have the exact possible dates yet.
Presidency.
Now we do have the possible dates. It's amazing. And, but, so you want to tell us what those possible dates are?
So the proposed dates that we're currently looking at are Wednesday, February 7th, Thursday, February 8th, Tuesday, February 13th, or Wednesday, February 14th.
And you don't have to discuss those now. They'll be, again, in a Google Doodle, which is, and you can make your opinion on them.
Do we give you our preference now or we do it later?
We'll get both.
We'll send a email with a Google poll.
Okay,
and we'll
okay,
collect
got it.
everyone's availability. Yes, thank you.
So as this was the last item on the agenda, do any of the members of the board have any additional comments before we adjourn? Seeing none, I'll need a motion to adjourn for the record. Please clearly state your name and your motion.
Doyle so moved.
Second, Crawford.
All in favor?
Aye.
Any opposed? Any abstentions? Okay, it was unanimous. And in fact, the motion passes and we are adjourned and we'll see you in either February or March. Thank you very much.
Thank you.
You want us to just leave these?